74, United States of America versus Patricia Driscoll, Appellants. Mr. Storlas for the appellant, Mr. Smith for the appellee.
Good morning, Mr. Stolars. We'll hear from you.
Thank you, Your Honor. Good morning. May it please the court. Brian Stolars for appellant Patricia Driscoll. First off, I want to thank the court personnel for the very helpful manner in which we're doing this virtual court. Thank you very much to the court. Your Honor, in 1935, the Supreme Court stated that a prosecutor may strike hard blows, but he's not at liberty to strike foul ones. That platitude gets thrown around a lot, but this case is the embodiment of it. This whole case was broken from the very beginning due to misconduct by the investigative agent that was compounded by misconduct by the prosecutor who sought to cover for that agent. And the only way this kind of misconduct doesn't happen again is accountability. As a criminal defense lawyer, I hear things like accountability and deterrence all the time. And yet here we are, the government doing this conduct, and there's no accountability. The agent in this case took the Constitution into his own hands. He sees an exciting new case on a sports website. He's a brand new agent. The district court called it the Moby Dick, the white whale case. He hears she is testifying at her child custody hearing, where the child will spend holidays and school. He admits he knows less than 5% of the case and wants his case badly. The prosecutor agrees that the agent, Agent Baldini, should go to the child custody hearing and hear Ms. Driscoll testify. It was a team decision. The prosecutor tells him, though, don't badge in. Don't gain entry with a badge. Still unsure what that means. But there's no formal covert operation plan approved. The prosecutor admitted at trial. Yes, sir. Yes, Your Honor.
I'm assume I'm sold on everything you've said. Assume I'm sold that there was prosecutorial misconduct here. Can you explain why there was Brady prejudice? Why should we reverse the case when you ultimately got all the information in time to use it at trial? And in particular, I would ask, do you know of any one case from the DC Circuit where the DC Circuit has reversed a district court guilty verdict on the grounds of Brady when the Brady material was in the hands of the defense, at least by the time the defense began its case in chief?
Thank you, Your Honor, and thank you for that question. I believe the court tried valiantly to remedy this trial for the Brady evidence, and there's two reasons why it was insufficient. One, a Brady remedy cannot remedy a lying government witness. Agent Baldini, it was very specific to where and how this case came out. We received the Brady. The judge called a mini trial during the trial, and during that mini trial, the agent testified outside the presence of the jury and didn't do well. Realized he had been caught. And by the time he testified in front of the jury, he cleaned it all up. And there's nothing as a defense lawyer that I could do to remedy that. He said, for example, in front of the jury, he got consent from a supervisor to conduct surveillance. Well, that made it look more official. That had never been given to me before. I was blindsided the entire time. I did the best I could with it, but that's not the standard. And he lied
all these arguments you're making, you were able to make to the jury in order to hurt his credibility, correct?
That is absolutely correct. Yes, Your Honor, I did.
So is there an answer to my kind of yes or no question on, do you have a DC Circuit case that reverses a district court conviction when the Brady evidence in question did make its way into the hands of the defense, at least before the defense began its case in chief?
No, Your Honor, I don't. And the judge noted that, which said that the prosecutor was lucky that I got it when I got it. If I got it a week later or 2 weeks later, it would be in a different posture. And I fully acknowledge that. But I believe, Your Honor, this is bigger than Brady. I believe this case was fundamentally broken from the very beginning. So even if you take a step behind Brady and look to the Tweel case, which is the best I can find in the Fifth Circuit, I realize there's limitations in that case. It's a Fourth Amendment case because you're dealing with an agent who lied in that case about a civil audit and asking the person asked, is this a criminal audit or is there an agent involved? No, and they produced the documents. In this case, Judge, we have the Fifth Amendment being violated. So I think this goes beyond Brady. And that's the point that I really want to stress, which is if the agent sits in a child custody hearing and Ms. Driscoll goes to him and said, are you worked for the government? And he says no. Her consent to go up there and testify is gone. So the whole case gets cracked from the very beginning. Yes, I understand about the Brady issue, and I fully understand your Honor's point, and I frankly agree with what Judge Leon said. I got it. I don't think I was able to use it effectively, but I got it. But this case was cracked from the very beginning. And Agent Baldini admits this. He said, I did not want it to be overt for Ms. Driscoll to know we're investigating her yet. The only context I know of where you can lie is when you're doing custodial interrogations. Back to my old public defender days when you used to have to litigate that. There's no context like that here. The court asked who he was, Agent Baldini lies. Ms. Driscoll asked who he was, Agent Baldini lies. His lawyer asked who he was, Agent Baldini lies. He holds the Constitution and says, you know what, I'm going to take it in my hands such that you can't consult with your lawyer to see if you want to take a timeout, see if you want to testify or not, such that the judge himself cannot admonish the witness to seek counsel. I mean, that what I think is even a bigger question is what he usurped, not just the role of a defense lawyer who could tell a person, advise him of a constitutional right.
Is there any authority, though, that even if he had disclosed that he was a government agent, that the judge at that proceeding had any obligation to warn Ms. Driscoll before she testified?
No, I think it's what I've seen is common practice. In fact, Judge Leon did that in the district court when one of the witnesses had exposure.
But
took the time out and asked them.
I guess my point is that Ms. Driscoll was testifying. It's an open proceeding. The government or the public or anybody could get a transcript of it. So there's no expectation that she has that whatever she says can't be used against her. Why would we have any expectation of that?
Well, you're absolutely right. And there's irony to that. If the government never went, they could have easily gotten a transcript and they could have used whatever she said for their investigative purposes. It's the moment that Agent Baldini inserts himself in the process and lies to her and says, I am not a government agent. It was a point blank question. First day, are you work for the court? No. Second day, he comes back. Do you work for the government? He says no. Therefore, she feels comfortable to testify. So because he inserted himself, Judge.
But if he had never showed up, she would have been just as comfortable and would have said this exact same thing, and the government could have obtained the transcript and you would have been where you are. I mean, it seems to me that if there's any real misconduct here, it's when he goes to lunch and does the other stuff. But I'm just not understanding what constitutional right or egregious misconduct takes place by him not identifying himself in the courtroom.
Well, the best that I could do, Judge, is make the analogy to Tweal, which is I acknowledge the limitations of the Fourth Amendment case. In that case, they say, is there a criminal audit? No. So they produce documents. In this case, she says, are you a government agent? If he says yes, then she will consult with her lawyer, but she will, the judge may admonish her, hey, you might want to get your own criminal defense lawyer. And then she may not testify. But Agent Baldini took the Constitution in his hands. That can't be permissible. I understand you're allowed to lie to a witness in interrogation, but not in this context when you are purposely hiding who you are to make her go and testify. He's going to watch her testify. So in doing that, he is taking the Constitution in his hands.
Was any of the civil testimony used against her in the criminal trial?
Yes, Judge. In fact, the agent admitted he issued subpoenas as a result of what he heard. He knew who to talk to. He knew which witnesses to call, and he knew what her defense was. She was a sitting duck for years. The same defense she used then, I used later in the trial, and it was all out there because he knew about it. So yes, and the government admitted that they made derivative use of the testimony. That's very clear, and I have the cite for it to JA 373. They admitted they made derivative use of the information. So this comes down almost like a fruit of poisonous tree in some ways. If he sits there and lies, and then all these things happen, he writes down, oh, I got to subpoena this bank. Oh, I got to subpoena this person. Oh, I got to take a witness. That he's violating the Constitution to get his roadmap. In a high-profile case, he's a new agent. He's a lawyer, by the way, a new agent, desperate for a white whale case. Prosecutors do not supervise him because as to the lunch, which I know I'm running a little short on time, that lunch is preposterous. It's one of the worst things I've ever seen. But yet the prosecutor doesn't inquire about a fourth-day memo and then makes the statement they made to the district court. They lied to the district court, and they said that he did not write a memo because nothing happened on that day, JA 254. If I wrote that in a pleading, or Ms. Driscoll wrote that in a pleading, we'd be investigated for obstruction of justice. But yet they can say nothing happened, and that's totally not true. The district court denied that.
Given the interest of time, do you want to argue about any of your other issues, particularly the jury instruction issue?
I can address that during my 2-minute rebuttal. I mostly rest on the papers on that. The courts flipped the order of the red book, gave an anti-deadlock instruction, then gave 2 others that missed the critical point of holding to your honest convictions rather than just saying keep an open mind. Sorry?
I'll just ask you 1 or 2 questions about that.
Yes, Your Honor.
I take it's not your position that there are 2 standard instructions, as far as I can tell, that in some sense are anti-deadlock. They are under 2.601 of the Red Book. And Roman 3 is the one that's called the Thomas instruction. There's also Roman 1, which is called the initial instruction. I take it it's not your position that it would be reversible error to give the initial instruction because it's materially different from what's called the Thomas instruction.
Correct. That's not my position.
And is it your point that in the hypothetical case where the district court starts with the initial instruction at the beginning, on the first deadlock notice early in the trial, he gives the initial instruction, then the jury deliberates more, second deadlock note, then he gives the Thomas instruction. Is that reversible error for giving the same kind of instruction twice?
Well, and that's the big debate. The government said the judge could not give an anti-deadlock instruction twice. The judge said he could.
What's your position on that?
I believe you cannot give more than one anti-deadlock instruction. And frankly, that's part of the role of this court, because there's a split in the circuits. There's a hodgepodge of wordsmithing on jury instruction cases that takes up a lot of time to parse each one. There's no clear ruling from this court on whether that can or can't happen. And so I do think that's the role of this court, to give us a firm ruling that you cannot do a repetition of an anti-deadlock instruction.
Suppose we disagree as to my hypothetical. What is it about flipping the order? This case is odd because the district court starts with the full-blown Thomas instruction the first time and then uses the Thomas light initial instruction on the third instruction. Why is it worse to flip the order than if he had just done exactly what the Red Book seems to contemplate, which is give the initial instruction first and then the full Thomas instruction second? Why is that worse?
Yes, Your Honor, because the instructions he gave afterwards were functioned as additional Thomas instructions because he omitted critical language. The Thomas instruction says a juror must hold their honest convictions. The instructions he gave afterwards were just keep an open mind. He said keep an open mind probably 5 or 6 times, but never said hold your honest convictions. So he starts with hold your honest convictions, but does not repeat it, which makes it, and that goes back to Thomas itself, which says we have to look to the functional effect on the jury. We had a holdout juror clearly voting for acquittal, we know now, and the multiple instructions afterwards were guided to that juror, and none of them said hold your honest convictions. It just said keep an open mind. So that is why they're fraught with danger.
Right, but that is permissible. I mean, that is how the initial instruction is formulated.
Correct, but that's why if you would go first to that and then hit a Thomas, then you hit the keep your honest convictions. And if he were to say keep your honest convictions every time, that lone holdout juror for acquittal may have done exactly that, but he didn't. I believe he was coerced and pressured. Thank you.
Okay, thank you.
So can I get clarification? You're now saying it is all right to give the initial instruction on one day and then the Thomas instruction on another day.
Right. No, I didn't, I don't believe I claim that as error that he did flip it. And I believe that the functional effect of the totality of the jury instructions was wrong. But the Red Book is, I believe, supposed to go first, then second, the pre-Thomas and the Thomas.
Right. And so if you go second and then first, instead of first and second, what's the difference? Why does that matter?
Well, Your Honor, as I just explained, when you go from the big heavy one to the light one, if you don't have the themes from the heavy one, which is hold your honest convictions, then the jurors are confused. And the totality is, well, maybe I don't have to hold my convictions anymore. Maybe I just have to keep an open mind. So that was directed towards that one juror. It was coercive. The totality was coercive. And I think, go back to my earlier point, this court needs to just lay it down so that litigants and judges can know, because the government said you can't do a second anti-deadlock. The judge said I could. So therefore, there needs to be a set thing that we could all have a level playing field to know what to do.
There's a case, United States v. Black, from this court in 1988. I'm going to read the additional instruction that the court gave there. And this is not a trick question. I'll tell you right now, the DC Circuit said that this additional instruction was not an additional Thomas charge. It's not the same as saying Thomas twice, or saying Thomas light and leaving out something that's got to be in Thomas. So here's the additional instruction. I'll now instruct you in response to your question that each juror is entitled to his or her opinions. Each should, however, exchange views with his or her fellow jurors. That is the very purpose of jury deliberations, to discuss and consider the evidence, to listen to the arguments of the fellow jurors, to present your individual views, to consult with one another, and to reach an agreement based solely and wholly on the evidence, if you can do so without violence to your own individual judgment. That seems very similar to what the district court judge here said in his final instruction to the jury.
Yes, Your Honor, thank you. And I read through Black, and the response I have to that is that the end part you just mentioned about without doing violence to your own convictions. I believe that the later instructions by Judge Leon stressed open mind rather than holding your honest conviction. So I agree, it's a bit of wordsmithing, and that goes back to my point that it's hard to find, where to put everything, because there's so many different types of cases. The wordsmithing to individual judges and litigants is very challenging. But I believe that he did not stress holding your own convictions as well as Black did in that case.
And he did say open mind, over and over and over again. I agree with you on that. It just, to me, seems like almost a truism of a thing for a judge to tell the jury. I mean, their job is to keep an open mind. He might as well have just said, do your job 4 times. It's, banal. It seems almost like it's a banal suggestion. It doesn't strike me as anything that would coerce anyone. So tell me why I'm wrong.
No, I'm not saying you aren't. I mean, it's a very valid point, Judge. The point, though, is in this particular factual instance, which is why all these cases are so difficult to reconcile, you have a deadlocked juror who told the judge that he's deadlocked, he's made up his mind. The fact that he doesn't tell that one holdout juror, we know we're dealing with one holdout juror, we now know for acquittal, telling that one holdout juror to keep an open mind and not also telling that holdout juror, hold your honest convictions, that's the problem. Because we know it's one juror, we know it's a holdout, we don't know at the time which one it was, which way he was going or she was going. So that's why it's wrong, because it's targeting a juror with coercive language, keep it up in mind, but not also telling that juror, hey, if you still feel that way, you should keep feeling that way. That's the only splice that I have for you. Thank you all very much.
Are there any other questions?
Yeah.
Thanks.
All right, we'll hear from the government.
Thank you. May it please the court. Peter Smith on behalf of the United States. I'd like to take the arguments in the order that they were addressed this morning by the court, starting with Appellant's Brady argument. The district court did not abuse its discretion in denying relief on Appellant's Brady claim. The main claim that Appellant presented this morning was that he could have better impeached Agent Valdini had he had more time to do so. And at bottom, our argument is that there simply isn't any materiality to this argument. Appellant had multiple opportunities to question Agent Valdini under oath. The court gave him a wide berth to do so. And there's no indication that any additional or better impeachment would entitle Appellant to relief under the Brady standard, which is essentially that you would achieve a different outcome at trial. Appellant this morning in oral argument and perhaps in reply is raising a new argument, an argument he characterizes, counsel characterizes as a Fifth Amendment argument. And this court shouldn't consider that argument because it is new in reply or in the oral argument. In the district court and in his opening brief, appellant made this Fifth Amendment argument as an aspect of materiality. He said he was raising a Brady, she said she was raising a Brady claim, and that an aspect of why the alleged Brady violation was material was that she either might not have testified or testimony might have been different if she had known about Agent Valdini's presence. And then I just have a couple of quick points about that. Appellant knew going in that this was a public proceeding. She didn't ask about Agent Valdini's identity until 3 hours into her testimony during the lunch break. And the district court made a factual finding that appellant's testimony at the child custody hearing hadn't been induced by the government or altered by the government. And that factual finding was not clearly erroneous given the lengthy evidentiary hearing the district court held. As I mentioned, the defense had ample opportunity to question Agent Valdini, to raise this before the jury, and even argued at length to the jury in closing argument that the government's conduct was improper and warranted, an acquittal in the case.
Mr. Smith, let me ask you a hypothetical. Suppose Valdini had done everything that he did. Suppose the district judge learned of it when the district judge learned of it. And suppose the district judge had said, as a remedy for this misconduct, I'm dismissing the case. I could just continue the case to give defense some time to prepare based on the new information they've learned. I could not do a continuance and just kind of make them play catch up. But in an extreme instance, in part as a prophylactic to disincentivize law enforcement from playing these tricks in the future, I'm dismissing the case. Do you think that this court could reverse that decision?
I guess it depends on the procedural posture. I mean, if the court is dismissing the indictment, which I guess is suggested by the court's question, the district court, is dismissing the indictment, the government would be able to appeal. And I think that that would be an abuse of discretion on these facts. There needs to be, in order to have some sort of due process violation and the dismissal of an indictment, truly outrageous, government conduct. And the district—
Why is this not truly outrageous?
Because the district court initially believed that what the government had done was somehow assist appellant's ex-husband in the custody case. And the evidentiary hearing bore out that that is not actually what happened. So what appellant is complaining about is Agent Valdini's presence, about his connections with these various people during the luncheon meeting, but none of that rises to the level of that kind of outrageous conduct that would warrant dismissal.
If the facts, as I think Judge Leon found them, are true, Valdini lied to a state judge. Valdini destroyed evidence, the fourth day's notes. Valdini lied to a federal court when he was asked, what did you talk about at the lunch meeting? And you don't think that's outrageous?
Well, I guess I think that is problematic, but I don't think it warrants, wouldn't warrant dismissal of the indictment. And I would add that appellant has never sought that remedy. So
what's to stop a future Valdini from doing all of this again, if at the end of the day, the government was not penalized for it?
Well, the government was penalized for it through the district court's admonitions, through the lengthy Brady hearing, through the fact that a defense counsel was able to raise all of this before the jury, which did in fact penalize the government's case. And I would add on the flip end of this is that, and this also goes to appellant's derivative use argument, that it's not, this case isn't just about Agent Baldini. This was a combined investigation that involved the FBI. The prosecutors were directing the investigation. The prosecutor explained to the district court during the Brady hearing why there really wasn't any derivative use of information that Agent Baldini had gleaned during the custody hearing. The government never used any statement or never introduced at trial any statement that appellant made during the hearing. And the prosecutor on November 8th in the afternoon transcript at pages 60 to 65 explained to the district court why the government hadn't used any of this information to direct its investigation. She explained that they had debriefed Tanya Finch, who was the whistleblower before the child custody hearing, that the prosecutors had already done a lot of legwork on the case and already had a game plan for the investigation. And so I would urge the court to look at that transcript reference. And then I would also say that the court, it is an interesting hypothetical, but appellant simply hasn't raised that claim that would warrant, has never asked for dismissal of the indictment. And therefore this court can't award relief that appellant has never asked for. If there aren't other questions about Judge Katsas, do you have a question?
No, I'm ready to talk about the instructions.
The instructions, okay.
So let me ask you about them. If we look at the totality of the circumstances here, you have 3 different instructions that are in the general ballpark of Thomas. You have the first one. First one looks like a Thomas instruction, but there's a lot of improvising. There's some improvising about how important a unanimous verdict is to the, not just to the parties in the community, but the whole country. The second Thomas-like instruction, seems like the comments are pretty pointed in the way they are directed to one juror. The court hopes that this juror will come around. And the third instruction, which looks a little bit like a Thomas Light instruction, that initial instruction from the Red Book, but it too has a fair amount of improvising with keep an open mind repeated over and over, and that might be a truism in the abstract, but in the context of these jury notes, it sure seems like it's an attempt to bully the one juror. When you put all of that together, why isn't that coercive?
I guess I have several different responses, Judge Katsas, if the court would bear with me. At bottom,
I asked a lot of different questions. So
so I'm going to sort of untangle those over time, and I just hope the court allows me an opportunity to fully explain. So first of all, the court's got to view the context of all of these different instructions and everything that's happening in the district court. Appellant has initially agreed to the giving of the Thomas instruction. So that's part of the context.
Agreed.
The court has got to consider.
Agreed.
And
there's the improvising.
Right. And then as to the improvising, I guess I have a few different points about that. First of all, it would have been clear to the jury that the Thomas instruction had ended because the court told the jury, okay, I've given you these 2 instructions. You're going to have them. Go ahead and consider them. And of course, I'm paraphrasing. And then the court went on to give what we call in our brief a pep talk, where the court sort of encouraged the jury. The court went on, and the jury would have understood that was different from the actual legal instructions. They would have recognized that difference. And they would have recognized that as a pep talk, as the court was trying to sympathize with the jury and urge them to keep going. There are, of course, 2 other factual aspects this court's got to consider. The jury went back and continued to deliberate for quite a while. It eventually issued partial verdicts, and then still spent additional time before it was finally issued all of the verdicts in that case. And that sort of shows that no particular instruction was coercive. Then I would add a few other facts this court's got to consider. The district court acted when it responded to the first note and it gave that sort of extemporaneous pep talk. The jury had only been out for 1.5 or 2 hours. So it was very early. And the district court looked at that and felt that the instructions were appropriate at that time because the jury had come back so quickly in such a complicated case. And then I guess the final response I would give, Judge Katsas, to your question is that the instructions, the 3 different instructions, were not coercive because the court, and this goes to the other language and also goes to Appellant's point about not surrendering the jurors' honest convictions. So the court several times reminded the jurors to keep an open mind, but it also said that the jurors needed to discuss their views, indicating that the juror who was refusing to deliberate had a view that was important and that that juror needed to discuss, and the other jurors needed to discuss with that juror's view. The district court also, in its final instruction, again reminded the jurors that they have to express their own views. And as Judge Walker indicated earlier, referring to the Black case, that is very similar to what the court did in Black. So when you add all those facts together, you add the context where appellant has asked for the Thomas instruction initially, you have a note that seems process-oriented. You have a note where the juror is refusing to follow the court's instructions and is not deliberating.
You're adding the is not deliberating. The note says the juror has made up his mind.
Yes, and the district court sort of discussed that on the first day before giving the Thomas instruction about the district court's view about what exactly that meant. And the district court found, among other things, that it indicated that the juror wasn't deliberating.
But if the district court made that finding, why did the district court give an anti-deadlock instruction instead of the Part 1 instruction in kind of an admonishment to just, deliberate instruction?
Yeah,
you can't have it both ways and say, well, this was only an indication that a juror wasn't deliberating when the district court essentially made a finding that there was a deadlock, or else you're not supposed to give the Thomas instruction until you found that there's a deadlock.
I appreciate the court's point, and I think the district court found essentially both, but the court needs to bear in mind that the context.
How can you find both?
Well, the context of this court's review of the district court's decision is where the appellant is asking for the court to give the Thomas instruction. He's agreeing with that, and defense counsel saying it's important to come out strong. So that's sort of the background of this court's evaluation of the district court's decision. The district court also thought that the Thomas instruction basically reflected or summarized all the points the district court wanted to make at that time. So he did explain his reasons for giving that instruction at that point. And again, appellant agreed with that. And therefore, that argument, the timing of the instructions and the giving of the Thomas instruction initially, that is waived, and this court shouldn't consider that as an independent.
Well, I'm not saying that it was error to give the Thomas instruction initially. What I'm saying is that the note said that the juror has made up his mind, or his or her mind. Okay.
Yes.
And in response to that, a Thomas instruction is given. There is a second note on the 27th that also says that a juror has his mind made up. And And then there's more instructions that are given where, again, the judge departs from the standard language. And then finally on the 28th, the jurors say, well, we have a partial verdict and we are deadlocked on 2 counts. So it's reasonable to infer that with respect to each of those 3 notes, the same juror has made up his mind and is deadlocked. And if you give an instruction that says, keep an open mind, after the juror has said, after it's been told to the court 3 times that this juror has made up his mind, how can that be construed reasonably as anything other than an instruction that you are to basically consider changing your mind, which is kind of the essential aspect of an anti-deadlock instruction, which has to be balanced with language that says, but don't give up your honest conviction?
I guess I have 2 responses, Your Honor. In the notes, there was also, I mean, I appreciate Your Honor's point about the juror's mind made up, but the jury note also said that the juror's mind was made up based, and I'm paraphrasing now, essentially regardless of the facts. And that indicates to me that there was a process element to this.
I don't recall anything that says regardless of the facts.
Well, let's see. He said, the first note is, he already had, this is in the transcript of the first jury note, it's page 25. He already has his mind made up and he is not basing his decision on the facts. So I'm just saying the district court and the parties seem to understand that there was some process element to this, that there was a refusal to cooperate and to deliberate. But setting that aside, and I appreciate Your Honor's point, I do have a response to that, even if it was a deadlock, even if this court construes that as a deadlock. The situation isn't that different from Dorsey, cited in the government's brief, where Dorsey says that in that case, a juror was singled out. The court had learned essentially the split among the jurors through a jury poll, and then instructed the jury to go back and deliberate. And this court said that the re-instruction and the instruction was not coercive, and it explained why. And so I think that given the constellation of facts in this case, Dorsey is instructive. And I would, in addition to what I said earlier, I would add a couple of factual points about what happened here. The court's instructions to the jury didn't telegraph an outcome. The court told the jury to keep an open mind, but it did also tell the juror his or her mind made up to discuss their view with the others, and for the others to listen to that juror's point of view. And that is similar to what happened in Black and other cases where this court has affirmed and found that those instructions weren't coercive. So, I mean, I understand when you look at it as
but I guess, you know, the cases that you have cited from our circuit, and you cite the McDonald case from the Second Circuit, the court basis of its assessment or its ruling or its holding that an instruction that just says keep an open mind and keep deliberating isn't coercive. It bases that on saying that in context, the instruction isn't asking anyone to kind of change their vote or to actually re-examine their views. It's just, telling them that, deliberation is hard, keep at it, etc. The essence of an anti-deadlock instruction that's coercive is either an explicit statement or an implication that somebody who has made up their mind and isn't budging should consider re-examining their views. So my question to you is, when the court is told 3 times that a juror has made up his mind, that's said explicitly twice, and then the 3rd time it said that the jury is deadlocked on at least 2 counts, which in effect means the same thing. And you basically give an instruction targeting that deadlocked juror, telling him to keep an open mind, putting aside what we've said in Thomas and its progeny about you're supposed to, not depart from the language. But when you tell a holdout juror who's made clear that they are the holdout to keep an open mind, why shouldn't we interpret that as tantamount to the juror being told, or that the juror would reasonably believe that he was being told, you should consider changing your mind?
I guess for several reasons, Your Honor. First of all, the court's instructions did have this other aspect of not only keeping an open mind, but discussing your views and expressing your own point of view, which acknowledges that that juror, the juror who was the subject of the note, had an important perspective to share. I'd also note that this court's Lope-Sierra decision, which is cited in the government's brief, indicates that reminding the jury of an instruction as opposed to rereading the instruction is less coercive. And of course, each time the district court gave one of these instructions, or 3 different instructions, as you pointed out, Your Honor, the jury continued to deliberate, showing that the juror whose mind was made up didn't immediately, that the instructions weren't unduly coercive because the juror didn't immediately turn their view around. The jury continued to deliberate. The jury rendered partial verdicts after a couple of days, and on the third or fourth day of deliberations, finally reached a unanimous verdict on all the counts. So those all show that the instructions as a whole weren't unduly coercive.
What do we do with the fact that the 3rd round of instructing on November the 28th, when the jurors sent a note saying that they had a partial verdict, the court responded with an instruction to keep an open mind, but the court did not, of course, have the language in there about not surrendering honest convictions. And the court also didn't reference the earlier instructions or remind the jurors of his earlier instructions, including the Thomas instruction that he had given earlier that had the language about not surrendering honest convictions.
Right, I agree with that, Your Honor. And I think that our answer is that the instruction on that day, the 3rd day, had a component that was similar to Thomas, that said that juror must express their own point of view. And that is, I believe it's in the November 28th transcript at page 15. The court asked the jury to continue deliberations and to keep an open mind, but then said, with a view of listening to others and expressing your own point of view, which is similar.
What are we supposed to do with the holding of Thomas and the holding of several cases after Thomas that says that the language of Thomas is what's supposed to be given and that anything else is presumptively coercive and reversible?
Yeah, I think the court's, this case is distinguishable from that precedent like Yarborough, where this court said that the district court shouldn't make any substantive departure from Thomas, and the court gave the Thomas instruction verbatim, The court then later referred back to the Thomas instruction, but didn't reread it. And then the final instruction that we just discussed, I would say, is not a substantive departure from Thomas. It's consistent with it. It's similar to it. The language isn't exactly the same, but the court was giving an instruction that included both aspects of keeping an open mind, but also expressing each juror's point of view with the view toward listening to what they had to say.
Expressing, telling the jurors that you should feel free to speak your point of view to others is nothing like saying, don't surrender your own honest convictions solely to reach a verdict or solely because other jurors disagree.
I think the point is the same, Your Honor, and I think the jury would have understood it.
How is the point the same that you have a right to speak out? That's not the same as the point that you have a right to maintain your convictions.
Well, I think it does.
And not change your vote if it does violence to your honest conviction to do so.
Right, because the court wouldn't, I mean, what I'm saying is that the district court wouldn't be telling the jurors to express their point of view if their point of view didn't have legitimacy or if it weren't important. That's all I'm saying. So that the court is recognizing both aspects, keep an open mind and deliberate with the others, but also express your point of view, which has value. So you get both aspects there. So I don't think it's a substantive or substantial departure from Thomas. I think it's consistent with Thomas. So that would be my answer to the court's question. But as to the overall question of whether reversal is warranted, I would go back to my answer to Judge Katsas and say that the court's got to look at all the instructions together. It's got to look at the entire procedural posture, which includes appellant's counsel asking for the Thomas instruction initially. And it's got to look at each of these notes and what the juror notes said and what the court's response said. And so we think that cases like Dorsey and Black are instructive and that the instructions that the district court gave weren't together unduly coercive. They did not coerce that individual juror to change their settled convictions or their honest convictions.
Judge Katsas, Judge Walker, do you have any further questions for the government?
Nothing more.
Just one question. Where's Valdini in terms of, has he received kind of a reprimand by anyone in the executive branch?
Oh, I don't know the answer to that question, Your Honor. I'm sorry. The last I knew, he was still working at the IRS, but I don't know the answer to that question.
All right, thank you. I'll let you make any closing statement in conclusion.
Thank you, Your Honors.
All right, thank you, Mr. Smith. Mr. Stolars, you were out of time. I'll give you 2 minutes for rebuttal.
Thank you, Your Honor. Briefly, as to the Fifth Amendment question that the government said it was just for the Brady materiality, that's, with all due respect, plainly false. I filed an independent motion to dismiss. I filed an independent motion for mistrial and a post-trial motion for dismissal based on the Fifth Amendment issue. So therefore, it's not ensconced under the Brady. It's a separate issue where a separate ruling was made. As to the issue about whether or not derivative use was used and the government attempt to sort of take that, downplay that, the government prosecutor herself at JA 373 said, the witness testified they did take derivative use of the information they received. That's not in dispute. And I questioned the man and I said, did you issue subpoenas from this? Yes. Did you talk to witnesses because of this? Yes. It was clearly derivative use. He didn't go there to find out where her son was going to spend Christmas. And then finally, as to the jury instructions, I do want to note that the second instruction goes to the court's point about targeting a juror. The second instruction told the juror, I hope you will come around to keeping an open mind. That's directed at one person. Coming around is exactly what he's trying to tell him to do without giving to not surrender his honest convictions. And then the final instruction after the partial verdict was announced, he said, keep an open mind 3 times, but did not say, hold your honest convictions. Your Honor, I do want to end by saying that if this is the way the system works, we're all in trouble. They said they were going to give H. Valdini a talking to, like when my kid, spills his drink. Like that's not the response here. There's OPR complaints. I've not heard anything about there, but asked to give statements. Judge Leon said it best. It's a cavalier approach, sloppy and careless. It's about fairness, about conducting the powers of the U.S. government in a fair way against an individual. That's what this is about. And Judge Leon said the attitude of the approach to the government has no place in the Department of Justice, and we agree. Thank you, Your Honor.
Thank you. The case is submitted.
Case number 19-5070, United States of America versus Douglas F. Greer, MD, and Douglas F. Greer, MD, PC, doing business as Downtown Ophthalmology Center Appellants. Mr. Kumar for the Appellants, Mr. McDaniel for the Appellee.
Good morning, Mr. Kumar. We'll hear from you.
Good morning, Judge Wilkins. May it please the court. Suraj Kumar for Dr. Doug Greer. The district court ordered Dr. Greer to sell his house and hand over the proceeds to the federal government. That decision should be reversed for two reasons. First, the government's 2016 claim alleging breach of a 2007 settlement agreement is barred by the 6-year statute of limitations. Second, even if the government's claim were timely, the agreement is unenforceable because it would require the sale of a house without providing a sale price, how that price is calculated, or when the house must be sold. The government's claim is time barred based on the text of the statute and the agreement, the undisputed factual record, and sound policy. Under 28 USC 2415A, breach of contract claims shall be barred unless the complaint is filed within 6 years of when the right of action accrues. And the government concedes on page 41 of its brief that a claim accrues when the events necessary to state the claim have occurred, not when the government discovers the breach. A separate provision, section 2416, holds a limitation period when material facts are unknown. The government expressly disavowed reliance on that provision before the district court, and it doesn't rely on it here. And the government's own authority, United States versus Commodities Export Company, says that the government can't unilaterally postpone the accrual of a claim. The text of the agreement reflects performance within months, not years. The express purpose is to avoid the delay, inconvenience, and expense of protracted litigation. And paragraph 3, the False Claims Act waiver, shows that the parties knew how to waive statutes of limitations and didn't do so for breach of contract claims. In fact, the parties separately referred to breach of contract claims and expressly carved them out of the agreement. Paragraph 5.
When the agreement was reached in July, I believe it was signed 2 days before Mr. Greer's sentencing. Or Dr. Greer's sentencing? Am I correct about that?
Yes, Your Honor.
So at that time, the parties didn't know what his sentence would be, correct?
That's correct, Your Honor.
And the parties didn't know whether he would be stepped back or remanded into custody after his sentencing. Is that correct?
Yes, Your Honor. One thing I'd like to say, though, is that the government relies on the 51-month potential sentence, an argument that they didn't make before the district court. But I think contract interpretation is about the shared expectations of the parties. And Dr. Greer opposed that 51-month proposed sentence. The other point
I understand that, but the guidelines range encompassed 51 months, right?
Yeah, that's my understanding, Your Honor, yes.
And I guess here's where I'm getting at, is that whatever expectations or hopes Dr. Greer had, there were no guarantees, and it was certainly a reasonable possibility that he would go to prison, that he could go to prison for 3, 4, 5 years, in that he might even be remanded in custody in 2 days after signing this contract at his guilty plea. And so that being the case, why should we hold that the only reasonable way to interpret this is that he had a duty to sell this within 6 months?
So I'd like to suggest sort of 3 sources for showing that 6 months is a reasonable time, and then make a broader point about the reasonable time analysis in this case. I think the court should break this down into time periods. So the first time period is between July 2007 and November of 2007, when Dr. Greer was performing his obligations under the agreement. That is, he paid $189,000 to the government in September of 2007. He made restitution payments after emptying out his retirement accounts. And if the court looks to the text of the agreement, paragraph 2 says that he shall do 3 things. And he did 2 of those 3 things in 4 months. That's a pretty good reflection of the party's expectations. Now, as to the time that he, and by the way, I would point out that the district court's holding against Dr. Greer on summary judgment, which is really an inference, is flatly contradicted by the actual performance history. The district court said his life was too chaotic for him to perform the agreement, but he was performing both his civil and his criminal obligations. Now, as to the time that he was in prison, it was reasonable for him to have the house sold at that time because, as the government points out in its brief, his wife lived just a few blocks away, and a realtor could have assisted with the sale. It's not as if Dr. Greer had to be present at every showing for the house to be sold. And I think it's notable, as Your Honor pointed out, that there was a criminal sentence contemplated, but the government didn't toll the statute of limitations, nor did the government make the obligation to sell the house conditioned on Dr. Greer's release from prison. And the government could have done either one of those things, or the government could have exercised its enforcement discretion and waited until he left, even under our view of the contract as written, waited until he was released from prison. And it would have still had 5 years to sue Dr. Greer for breach of contract. But it didn't do any of those things. Instead, there was no contact between the government and Dr. Greer for 8.5 years. And it's notable that the government doesn't cite a single case.
But all we have to find is whether or not it's the reasonable, the proper interpretation of the contract is that performance. That the performance of the selling of the house had to occur within, I think it's 2 years, 9 months, and 3 days, or whatever it is, right, by April of 2010.
Correct, Your Honor. And I think that brings me to the third period that I was going to get into, which is the time that he was on supervised release. The same thing that I said about his time in prison, that his wife or a realtor could have handled the sale, is true then. The district court said that he was on home confinement. And that's true. That was only for 6 months. And even as to that 6-month period, the conditions of his supervised release show that he was able to leave his house with permission. And he, in fact, did. As he testified at his deposition, he left the house to attend his son's graduation in 2009. Now, in the face of all of that, in the face of performance within months, the text of the agreement, and the fact that the government knew how to, waive or extend time periods, the government insists that there was this intent for him to rebuild his life based on an extended performance period. One thing I would note, I was going to say earlier, paragraph 5D of the agreement, because that's something that the government cites in its brief. It's at page 17 to 18 of the appendix. That provision, it refers to claims based upon such obligations as are created by this agreement. so breach of contract claims, and it expressly carves them out of the agreement. So it says those claims are excluded from the scope and terms of the agreement. So the parties didn't agree to do anything with respect to breach of contract claims, let alone postpone accrual or waive or extend the statute of limitations. I think what that provision is intended to do is clear from the plain text. So it's intended to waive the limitations period for a False Claims Act lawsuit regarding the allegations settled herein. Those allegations, as is clear from the first page of the settlement agreement, date back to April of 2000. Now, so by 2006 or 2007, that's when the government would have to file a False Claims Act lawsuit because, as Justice Thomas pointed out in his opinion for the court in Graham County, the False Claims Act clock starts to run on the date that the false claim for payment is submitted. And so by 2006 or 2007 or even early 2008, the government might not be able to both A, determine whether Dr. Greer had performed under the agreement, and B, file a False Claims Act lawsuit against him. So that's
Mr.
what that.
Kumar,
Yes, Your Honor.
on the first page of the settlement agreement, it says it's the first whereas. And it says, whereas the United States determined that Greer violated the False Claims Act when he knowingly submitted claims for payment for services not rendered or not necessary during the period April 1st, 2000 through December 31st, 2006. So let's take whatever he did illegally on December 31st, 2006. When would the 6-year statute of limitations run out for the government to bring a False Claims Act prosecution against him?
So, Your Honor, if it was a false claim submitted on December 31st, 2006, then yes, the limitations period would expire on December 31st, 2012. But to be clear, the clock starts running on the date the false claim for payment is submitted. So it's just as likely that the intent was to preserve claims based on the earlier allegations. The other point that I'd make, Your Honor, is that relying on...
Each claim has a separate limitations period, right?
Yes, Your Honor, depending on the date.
It would just depend when the claim was made, right?
Yes, Your Honor. And so the other point that I'd make, though, about paragraph 3, the False Claims Act waiver, is that relying on that provision to be an implied indefinite extension of the breach of contract claim accrual period or limitation period essentially reads paragraph 5D out of the agreement because the parties didn't reach any agreement. And there's also case law saying that limitations, waivers of limitations period need to be express and unequivocal. Now, this would be
let me go back, Mr. Kumar. It is, I think, not a Michelangelo in terms of contract drafting, but we have to take the textual clues that we have. It refers in the first whereas to false claims made through December 31st, 2006. Maybe the last claim was made November 30th, 2006, but if it had been made November 30th, 2006, it seems reasonable that this settlement agreement would have said through November 30th, 2006. I think the best implication, it's not, infallible, but the best implication of this language is that the government thought he had made false claims through December 31st, 2006, namely that he made at least one false claim on December 31st, 2006. Now, if that's the case, the statute of limitations for bringing a suit to hold him accountable for that statute of limitations would run out December 31st, 2012. And everything I got a follow-up question, obviously, but everything I've just said is correct?
Your Honor, if I could just make one caveat to that, which is that suppose the government, suppose in fact there was a claim submitted on November 30th, 2006, and that was one claim, but many of the other claims have been submitted, in 2000 or 2001 and 2003. A False Claims Act lawsuit filed in 2012, it couldn't be based on those earlier claims, right? So I think that is my point about what a better interpretation of that provision would be.
No, I get it. I get it. But let's say that there was a false claim made on December 31st, 2006 the government could bring suit with regard to that one false claim on December 31st, 2006. They could bring that suit as late as December 2012, correct?
Yes.
Okay. And then when you go to paragraph 3, we're looking for textual clues about how long the parties expected it would take Greer to sell his house. And section 3 basically says you got to document that you sold your house. And if you don't document that you sold your house, we can bring false claims acts against you. That makes total sense. There would be no need to add the last sentence of paragraph 3 if the expectation was that Greer would sell his house before December 2012, because the last sentence says the statute of limitations for those claims, for the false claims, that statute of limitations is waived by the signing of this agreement. So tell me why that isn't the best textual clue we have that the people who made this inelegantly drafted contract anticipated that it might take Greer longer than December 2012 to sell his house. And if they didn't anticipate that it would take him longer than 2012 to sell his house, what is that last sentence doing in paragraph 3?
So 3 responses, Your Honor. First, as to the point that there would be no need for the provision, I think my point stands earlier about the earlier allegations. Second, by relying on paragraph 3 to extend section 2415, the court would be reading an implied waiver as to breach of contract claims, even though those claims are carved out of the agreement. So the parties didn't agree to do anything with respect to breach of contract claims, right? And so
you're assuming that the breach happens if he doesn't sell his house within a year or within 2 years. But if we're trying to figure out what's the reasonable time to perform, what's the reasonable amount of time to sell the house, then this is not an implied waiver of a contract term. It's an incorporation of an implied contract term, namely the implied contract term that says he has 6+ years to sell his house.
Well, Your Honor, I think what you would be doing if you read it that way is postponing the accrual period for the breach of contract claims in violation of paragraph D. But even if the court doesn't agree with me on that, I think it would really be inferring something from nothing, because the parties didn't provide for an extended or flexible time period for performance. They said he shall do 3 things. He did 2 of those 3 things in 4 months. And I think that's why at sentencing, and this is at page 283 of the supplemental appendix, the prosecutor said that the government was grateful to conclude everything at once. That's what this was. This was a global civil criminal resolution. That's why he was making payments and doing everything except for sell the house in 2007. So to read a sort of alternative reality and say, actually, we wanted to give him time to rebuild his life, or he actually had years to do this other thing, even though he did everything else in 4 months, I don't think that's plausible. I think the other point, sorry.
I'm gonna ask you to guess something, and I acknowledge that you can't guess with perfect accuracy, and I would also acknowledge that you probably don't have an incentive to guess as accurately as you could. But if the government came to him a year after the settlement agreement and said, we want you to sell your house, and he says, I'm in jail, it's not reasonable to expect me to sell my house right now. And our contract didn't say I had to sell it right away, and so we should read the contract to allow a reasonable amount of time for me to sell my house, and I just can't get it done right now. Don't you think that's exactly what he would have said? And don't you think that his lawyer would have had a pretty good argument at that point?
So frankly, Your Honor, I think that would have been a tough argument, an uphill argument, because we would be in the same position that the government's in right now, because the government would say, well, what do you mean the contract, it's not time for performance? You already performed in 2007. You paid $189,000 in September. So I think that would be a tough argument, because we would be arguing for an extended performance period as the government is now without any evidence in the factual record or the text. Now, I want to be clear, though, that the government, it's not like the government was out of options, right? So as I mentioned, the government could have, in its enforcement discretion, decided not to sue, and could have done so anytime between 2009 and 2016. It didn't do that. The government knew he was going to prison, didn't toll the limitations period or make the obligation expressly contingent on his release from prison, didn't do that either. There's no contact for 8.5 years. And I think that's why ruling for the government in this case would actually be a pretty broad ruling with harmful consequences, because it would be incentivizing sloppy contract drafting. It would encourage open-ended obligations to the government and discourage prompt recovery of False Claims Act claims. Whereas a ruling for Dr. Greer, because this is such an extreme case, I think it would be fairly narrow and confined to the facts of this case.
My last question is, anything in the record of why he didn't sell the house?
So, Your Honor, at his deposition, he testified that after emptying his retirement accounts and paying the $189,000, he just thought everything had gone away. But what I'd point out is that that deposition happened 10.5 years after the agreement was signed, which is precisely why we have statutes of limitations. Dr. Greer is 80 years old. Understandably, he didn't remember much from that time period. But in the words of the Supreme Court, statutes of limitations are pervasive legislative judgments that protect not just defendants, but also courts from having to sort through all this stuff when there are, stale claims and fading memories. And that's why I think holding that the claim is time barred is appropriate here.
Okay.
Mr. Kumar, you are asking us to grant your motion for summary judgment and deny the government's motion for summary judgment. That was the position you took in the district court. You are not saying that the determination of what is a reasonable time to perform is a jury question.
Correct. It's a question of law, Your Honor.
And one other question: at the time that the settlement agreement was executed, the parties didn't know the amount of the fine that the court would impose, correct?
I believe correct. The court hadn't ordered the restitution at that point. And
the fine. Ultimately, Dr. Greer received at his sentencing 2 days later a $50,000 fine. But the fine he was facing under at least a healthcare fraud claim was up to in excess of $2 million, because it could be up to double the amount of loss, correct?
I'm not sure of the exact details of that, Your Honor, but I think if what Your Honor is suggesting is that because the punishment was very severe, the government intended to give him a longer time to perform, that's just not borne out by the record. On the same page that the prosecutor talked about that being grateful to have resolved everything at once, the government said he stole these things, he needs to give them back. So I think to say that, so first of all, what the question implies, I think, is drawing an inference against Dr. Greer. But Your Honor correctly pointed out that we're seeking an order directing summary judgment for Dr. Greer. There's no evidence that the government wanted to give him time to rebuild his life or wanted a flexible time period. And one would think that if that were the government's intent, there would be something in the contract or a statement at sentencing or something, an email or something like that they could point to. But this is really just an after-the-fact excuse for nearly a decade of delay.
Well, I guess the point that I'm getting at here is that the amount of the fine and the restitution and the assessments was right around $1.3 million. And Miss Dr. Greer was able to pay all of that before he went to prison in November by emptying out his retirement accounts and et cetera. But that wasn't a given. If the court had fined Dr. Greer $1 million, he wouldn't have had enough money to satisfy his fine and the restitution and the assessment. and he would have needed to sell the house in order to make up the difference. And as you mentioned, enforcement proceedings, but an enforcement proceeding that the government could make to kind of force the sale of the house to recoup the amount of the fine or restitution, that can be made 20 years after sentencing or after the defendant gets out of prison. So I guess the other context of this is that the government can wait a long time to act if it wants to. It's probably not prudent for it to, but the whole statutory scheme says that for the fines and restitutions, if the government waits 20 years, I mean, that's the statute of limitations for the government to seek to enforce that aspect of the criminal judgment. And those things were to be paid before the civil liability that was agreed upon in this civil settlement was to be paid. How are we supposed to kind of think about that in the context of making this decision?
Your Honor, I think that the sort of global civil and criminal resolution actually favors a shorter period rather than a longer period. And let me explain why. So the text of paragraph 2 says that he had to do 3 things first. Then it says that the proceeds would be applied to criminal, civil, and tax purposes. So he was performing the obligations concurrently. So for example, the $189,000 payment, that was solely towards a civil agreement. It's not as if, okay, the agreement doesn't say, okay, do all of your criminal stuff first, and then you can satisfy the civil agreement. What it says is you have to do these 3 things, and that'll result in settlement proceeds.
The agreement does say that you have to pay off assessments, fines, and restitutions first.
Yes, Your Honor, but
says that.
I apologize, Your Honor. What I was going to say is that but it doesn't. So the thing that we're looking for here is the time that he had to sell the house. It's right. So that isn't, if the court looks to the text of the agreement, it doesn't say you can do these 2 things and then do this years later.
But what I'm saying is that if he had been fined $1 million when he sold the house, the proceeds would need to go first to pay whatever the balance of the fine was that he couldn't pay, that couldn't be satisfied with his liquid assets.
Yes, Your Honor.
And the government would have had 20 years under the criminal enforcement statutes to force the sale of the house to pay off that fine. It wouldn't have been 6 months. It would have been 20 years after he got out of prison. And so I understand that that's not the facts here, but when you signed the agreement, you didn't know whether that would be the case or not. That's my point.
Fair enough.
You didn't know what the fine amount would be. And if the fine amount had have been in excess of what his liquid assets could cover, to where he was going to need the sale proceeds of the house to cover the fine amount, then the government could have taken its sweet little time to force the sale of the house to do that. Does that have no relevance to this question?
Well, Your Honor, if that were the case in that hypothetical, then yes, the government would have more time, but that would be under its criminal restitution statutory authority. So in this case, the government is acting as a contracting party, and the same standards that are applicable to other private contracting parties apply to the government, except to the extent they don't, I think the government should be held to a higher standard, not a lower standard, right? So I don't think it reflects a longer period, because I think if there had been an intent to have this drag on for years. The prosecutor at sentencing wouldn't have said that the government was grateful to have concluded everything at once, and the government wouldn't have entered into this agreement with the purpose of avoiding delay.
All right. Judge Katsas, Judge Walker, any other questions?
Not for me.
All right. Thank you, Mr. Kumar. We'll give you a couple minutes on rebuttal. Mr. McDaniel, we'll hear from you.
Thank you, Your Honor. Good morning, and may it please the court. First of all, we want to get rid of this notion that this was a vague or unenforceable agreement. Appellate really didn't address that significantly, but we think it just should be dismissed outright. First of all, it conflicts with the notion that this contract should have been performed in 6 months. This is their conclusion right out. So they seem to be going down that road and not taking a position that this is vague and unenforceable. It also conflicts with Greer's having paid $189,000 on the contract. Certainly he wouldn't have paid it if he thought genuinely that it was a vague and unenforceable agreement. Third, it conflicts with all of the admissions that Dr. Greer has made about the enforceability of the settlement, basically conceding that this is an enforceable settlement. Now to come in way after the fact and say this is somehow not a valid agreement, we think just flies in the face of what actually exists here. This is a settlement in essence that was desired by Dr. Greer and really favored him in this particular instance. It was raised for the first time by his own attorney at the May 3rd plea hearing there at Supplemental Appendix 27 and 28 and 53. In addition, it was mentioned prominently at sentencing, so much so that he had to file a supplemental sentencing memorandum on the day of sentencing. And we see comments about the settlement by the court at Supplemental Appendix 336 and 37. And these are fairly significant comments by the court that reflect just the extent to which the court embraced this civil settlement. If it pleases the court, I'd like to read select portions of that transcript.
Well, can I just ask you a question? Suppose the government had filed suit for breach of contract on, let's just say, March 31st, 2010. And they said, look, it's been almost 2.5 years, maybe over 2.5 years since this settlement agreement was formed, and it's not the least bit unreasonable to sell a house in 2.5 years, even accounting for the time he was in prison and so on. You think the court would have said there was no breach of contract in that case because not enough time had passed for him to sell the house?
Well, in this instance, I think the hypothetical puts it approximately a year after his release from prison.
Well,
and
I'm trying to put it right before the limitations cutoff, which I think is April 2010.
I see. And so in this instance, I think that we still would be in a period of time in which performance was arguably possible within that period of time. But I don't believe that, based on an analysis of the contract, that this is when it was reasonably expected by the parties, based on the language of the contract and based on the reasonable circumstances surrounding the negotiation of the contract. So here you have
if the contract were silent on timing, you agree that 2.5 years would be beyond the bounds of reasonableness?
No, not in this instance, because in this instance, it really depends on the party's intentions at the time of contracting. And here you have a clear link to the criminal case that's going on, and the fact that he gets sentenced, the fact that he has all these restitution, fine, and as well as his taxes to pay, which is part of his restitution. And here, you have not only that, but the structure of the agreement itself that says you have the False Claims Act waiver. And so you match the two together, and you see that if you look at the original 51-month guideline compliant sentence that was recommended by the government, agreed to by Dr. Greer in the plea agreement, and admittedly, he was able to argue the grouping issue for guideline purposes. He was also able to argue the 3553 factors, but putting that aside, he certainly could anticipate that Judge Leon would sentence him to a sentence that impacted approximately 6.25 years. And so that just so happens to coincide with the period of time that's waived by the False Claims Act. So we believe that you're looking at a period of time contemplated for performance of 6.25 years. And so here in these circumstances, we contend that this was a reasonable time for performance within that period.
Well, the other contextual point we know about the underlying false claims is that they are alleged to have occurred over a 6-year period. So just as plausible an explanation for the limitations waiver on the false claims is government had claims going all the way back to 2000. From the perspective of 2007, they would have been facing time bars for claims in the earlier range of that period. They would have been facing time bars right away. So the fact that they act to preserve the timeliness of those borderline stale False Claims Act claims doesn't really tell us anything about the performance time for selling the house.
We disagree with that. In the criminal context, this could be liability in the nature of a scheme. There were other people involved. So one criminal act that's alleged to have perhaps started on one date may not have ended on the date that it started. And so that it's certainly plausible here that we have criminal conduct that spanned a period of time, starting at one date, ending on another date. And so we don't think that this is necessarily a situation where you have multiple criminal acts that are being analyzed pursuant to successive statutes of limitations on the False Claims Act claim, but one's criminal scheme.
He's treating patients and he's billing for services that you all think are unnecessary. Each claim that he submits is a separate action under the False Claims Act.
Certainly, and
so each one is going to have its own limitations period.
Certainly, but you also have a situation where you have fraudulent conduct that is repeatedly engaged in over a period of time and could be analyzed as a scheme as well as separate acts. And so because of that, we contend that it's not necessarily the only way to analyze it as a separate act.
Okay, thanks.
All right.
And so, counsel, how are we supposed to interpret what is a reasonable time for performance? Are we supposed to look solely at what the parties thought as of the date that they executed the agreement?
Yes, we think that the analysis should be confined to the negotiation of the negotiation period of the contract and what the parties' intentions were as reflected by the circumstances surrounding that negotiation. And here,
your friend on the other side says that you can look at kind of post execution or post July 24th events to help inform what the party's understanding was. Do you agree or disagree with that?
Your Honor, we disagree with that. The parole evidence rule essentially prohibits that type of analysis, and the Clayman and Hartman decisions that we cite that certainly support that position. And we contend that that would be a flawed analysis. In fact, the analysis that appellant engages in which it basically jumps to the conclusion initially and discusses the statute of limitations without first analyzing whether when the reasonable performance period is, starting with the plain language of the contract and then looking at the circumstances surrounding negotiation is a flawed analysis without taking that approach that is recommended in the court's decisions or set forth, I should say, in the court's decisions. And that analysis here, we think, leads to the conclusion that Dr. Greer had at least 6 years to sell the house. And we believe consequently that we were within the 6-year limitations period at the time we sent him the demand letter and ultimately filed suit in this matter. Now,
just so that I get the government's position clear on the record, you've asked us to affirm. It appears that below you asked for summary judgment, of course, and you are not saying that the question of what is the length of time that is reasonable to perform under the contract is a factual question to be determined by a jury.
No, we're not taking that position. We agree that it's a question of law, and we understand the court is reviewing the district court's decision de novo.
All right. Judge Katsas, Judge Walker.
All set.
If I could ask a couple, going back to the parole evidence rule, the cases that you cite, do they stand for the proposition that a court should not consider parole evidence from conduct occurring before the contract was formed, or do they go beyond that and stand for the proposition that the court can also not consider conduct after the contract was formed?
I believe it does go to conduct after the contract is formed, particularly in the actual performance period. The question is, what are you trying to do? And it appears to us, based on the case law, that you're essentially trying to get to the heart of the party's intention. So, which
Mr. McDaniel, I will go back and read them, and I may well be misremembering what they say, but assume that those cases concern only parole evidence, excluding parole evidence that occurred before contract formation. What's your best argument if that's the case?
Best argument, Your Honor, essentially is that at the time the contract was formed, and I think the focus is, regardless of what you can look at, the focus is the intention of the parties in the circumstances of their contracting. And certainly the best evidence of that is what was going on at the time of the contract signing. Here, July 24th, 2007, 2 days before sentencing. Again, he's facing a lot of time. He's facing a lot of money. And his own attorney, if you look at the language of what he's saying, his own attorney is saying in the transcript, he makes statements regarding the need for a reasonable amount of time and a reasonable period again, on 337 of the supplemental appendix, reasonable period of time in which to make these payments. And this is in the context of him discussing the interest penalty as well. And so in that context, we see statements by counsel clearly saying that we want time to pay this amount off. And as well, we see from the record that even if you consider facts after the negotiation, you see that he was not really able to pay the criminal restitution and fine until days before he had to report to prison. So he had quite a bit of work to do. He was still trying to resolve his practice. He's still trying to liquidate his assets. It was not reasonable for him to be able to do all of this and at the same time prepare his life to go on to prison, as the district court noted in its opinion. So we think that looking at these criminal circumstances, the criminal case circumstances, and interpreting this agreement in that context certainly leads to the conclusion that he had time to perform the sale of the house, which was sort of in the analysis of the agreement at the end of the assets that had to be called upon to pay these various items.
Mr. McDaniel, my last question is similar really to one that I asked Mr. Kumar from his perspective. The contract is signed in July 2007. Greer is released from prison March 2009. It's your signature on it. You sent him a letter asking for a performance December 2015.
Yes.
So the period between 2009 and 2015, what took you so long?
Well, Your Honor, first, I wasn't personally involved, so it was for me an effort to recreate what exactly took place during that time. It was not clear to me exactly what took place.
Did you ask?
I did ask. Based on the information I learned, I could only speculate about what happened, but it looks like people were indulging Dr. Greer, but based on his son's circumstances, but that's sort of speculative on my part. I just don't know exactly what happened in that instance. So,
okay. Fair enough. I'm good.
All right. Thank you, Mr. McDaniel. Mr. Kumar, you were out of time, but we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. As to supplemental appendix page 337 that refers to a reasonable period of time, that referred to a period of months when Dr. Greer liquidated his pension plan. So I don't think that shows that 3 years or 8 years was reasonable. As to the government's reliance on Clayman, I think this is important. So the government relies on footnote 44 in Clayman. That says that parole evidence is inadmissible when the contract is silent to show that the contract would be performed at a particular time. It doesn't say parole evidence is inadmissible to show that the contract would be performed, just to show what a reasonable time would be. And if the court had any doubt about what this court in Clayman was saying, it could look to the Colorado Women's College case, which is cited in that footnote. There, the court made clear that parole evidence wasn't admissible to alter the written contract, but it was admissible to show what a reasonable time would be. And restatement section 204, comment E, makes the same point.
Can I ask you about that? And I'm particularly interested in following up on some questions Judge Wilkins put to you. So the way I was thinking about the case is contract is largely silent on time. So the governing legal rule that we read into it is reasonable time to perform. And then we look at the facts on the ground to assess reasonableness, and for reasons we've discussed, given the way things turned out, you've got a pretty strong case that 2.5 years is more than enough. But why isn't it better to think about this as on the question of contract interpretation? You read into the contract reasonable amount of time, and then you ask yourself, well, what would be a reasonable amount of time given what the parties knew at the moment of formation, when it might have turned out that he went to prison for 5 years and had the substantially greater fines imposed, and those facts would tend to show that a much longer period of time would be reasonable.
Sure. So I don't think that the looking at it at the formation point is necessarily as one-sided as that, because I think, if the government had all kinds of options, right? But the reason that I bring up there's a textual reason that I bring up
do you think it's right to assess reasonableness at the time of formation based on what the parties knew at the time of formation, or based on how things turned out?
So I think the court should consider both, right? So I think, because I think the textual point that I would make, Your Honor, is that paragraph 2 says that Dr. Greer shall do 3 things, and the actual performance reflects how the parties understood what that textual command meant. And Dr. Greer interpreted that to mean, I have to do this now. I have to do this in September, and I have to liquidate my retirement plans immediately. There's no textual evidence, and it's not backed up by any concrete evidence in the performance history that was the party's intention to have a separate years-long time for performance. If I could just briefly, Your Honor, say a word about, I know I'm over my time, but our second issue about enforceability, I would just say that we don't concede that the contract is enforceable, because this appeal is just about the obligation to sell the house. And to date, the government hasn't cited a single case enforcing a contract that was missing price calculation, and time. And we cite 3 cases, this court's decision in Queen versus Schultz, Rosenthal, and New Economy Capital, holding contracts unenforceable for lack of a price term, which just goes to show that this court would never enforce a contract like this between private parties. If anything, the government should be held to a higher standard, but at the very least, it should be held to the same standard. So if the court concludes that the government's 9-year-old claim is timely, we'd ask still that the court reverse because the contract is unenforceable. And in any event, we'd ask the court to reverse and direct the district court to grant summary judgment for Dr. Greer.
All right, thank you. The case is submitted.
Case number 20-1142 et al. PSSI Global Services, L.L.C., a State of Nevada limited liability company, Appellants, versus Federal Communications Commission. Mr. Diaz-Gavin for the appellant, PSSI Global Services, LLC. Mr. Wright for the small satellite operator, Appellants. Ms. Boisel for the appellee. Mr. Garangia for the wireless interveners. Mr. Werners for the intervener, SES Americom, Inc.
Good morning. Before we get started, I just have one housekeeping matter. The parties filed a sealed appendix in this case, but the briefs were not filed under seal, and no one has requested to conduct this oral argument under seal or as a closed proceeding. And so we are operating on the basis that there will be nothing referenced from the sealed appendix during argument. We don't intend to reference anything from the sealed appendix, and we expect that the parties will not either reference anything, at least specific information, identifiable information from the sealed appendix. And so that's the basis upon which we are proceeding. And if any party disagrees with proceeding in that fashion, they should let us know at this time. Otherwise, we will go forward. Does anyone have an objection to that? Okay, hearing none, we'll hear from, I guess, Mr. Gavin.
Thank you, Your Honor. I've reserved a minute and a half for rebuttal. May it please the court, my name is Stephen Diaz, and I'm representing the appellant petitioner PSSI Global. My argument today will focus on two statutes, Section 316 of the Communications Act and the Orbit Act. I will address them in turn. Although under Section 316, the Commission can modify a license, this court has made clear in community television and subsequent cases that such authority does not extend to the FCC's making a fundamental change in that license based upon the Supreme Court's holding in MCI versus AT&T. The verb to modify, the Supreme Court said, means to change moderately or in minor fashion and has a connotation of increment or limitation. In fact, the order has so fundamentally changed PSSI's transportable licenses, the authorizations for the satellite trucks that are essential for providing live advanced programming, so as to threaten the transportable business. In community, this court affirmed a modification because the licensees begin and end the trend under very similar terms. One channel digital or one channel analog. Not so here. The order takes away 60% of the spectrum available for operation of the transportables and imposes multiple technical limitations in the spectrum that remains. This is a fundamental change, precisely what the court said was impermissible in community and Cellco. PSSI cannot provide the same level of services when 60% of the spectrum is taken away. As can be seen from
If the commission makes a finding that this is not a fundamental change kind of as a factual matter, and they explain that finding and the evidence that they are basing that finding upon, then that is something that we owe deference to unless it's not based upon substantial evidence. Is that correct?
Your Honor, I think that there is substantial evidence that shows the contrary, that there has been a substantial change in the licenses.
But I guess you would agree that as a legal matter, we would review that for substantial evidence.
As a legal matter, you could review that for substantial evidence, yes.
Okay.
And is it the case, Mr. Gavin, that your side could have some substantial evidence, the FCC could have some substantial evidence, and in that situation, we have to rule for the FCC?
But no, not necessarily, Your Honor, because we have to go back to what is the statutory interpretation of Section 316. And as I indicated, the decisions of this court, based upon the Supreme Court holding in MCI versus AT&T, is that there cannot be a fundamental change in what is the license. And there has been. Right,
but I think Judge Wilkins was asking about questions of fact, factual disputes.
As to we are presenting substantial evidence that demonstrates that argues.
But again, Mr. Gavin, I think the standard, and please correct me if I'm wrong, is when it comes to a factual dispute, has the FCC provided substantial evidence? And I could be wrong here, but let's take, for an example, a factual dispute. You say that you won't be able to continue servicing your customers, and the FCC says that you will. And in fact, your customers, everybody from Disney to Viacom, says that you will. So if the FCC has put before us substantial evidence that you'll be able to continue doing what you used to do in terms of servicing your customers, then on the dispute of whether or not that's true or not, we have to agree with the FCC if they provided substantial evidence. Do you agree with that?
Your Honor, I return to my point that I think that we haven't gotten to this is not a situation where we're giving deference to the commission's judgment because they have ignored the dictate of the statute that a modification is not a fundamental
I agree.
change.
So, Mr. Gavin, I agree. It's for this court to decide the meaning of fundamental, find the meaning of modification, and our precedents tell us that in order to define that meaning, we look to the distinction between a modification and a fundamental change. But in order to take that test and apply it to certain facts, we have to figure out what the facts are. One fact might be you can continue doing everything you did before. One fact might be you can't do things that you used to do. And that's a disputed fact. We have to figure out, well, who's right? And you say you're right, FCC says it's right. And I believe that so long as the FCC produces substantial evidence and puts it before us that they're right, then we have to agree with the FCC on that disputed fact, right?
Your Honor, if we are dealing with simply have I presented substantial evidence or has counsel for the FCC presented substantial evidence, the cases you will defer to the FCC on substantial evidence.
Okay, and in terms of the evidence that you produced and put before the FCC, let's exclude the evidence that you've put before us as a reviewing court that you did not originally provide to the FCC. If we're only talking about information you provided to the FCC, I understand you told the FCC about the Iowa State football game.
That's correct.
Any other, which they say the guard band satisfies, put that to aside for a second. Any other evidence that you provided to the FCC that would show that when you're limited to 4.0 to 4.2, you can't do what you used to do?
Your Honor, first of all, the very basic, at several points during the proceeding, we noted that the difficulty of being able to coordinate, to do frequency coordination, for example, in order to be able to make the connection for our satellite, we had argued that before. The particular example that the commission has questioned is the Miami Hard Rock Stadium example that we used and included and is before the court. That's simply an illustration of the points that we were making previously. That's not something new. That's not a new argument that we raised.
Yeah, no, I know it's not a new argument, but I'm not asking about what arguments you made to the FCC. I'm trying to figure out, aside from the ipse dixit that you submitted to the FCC, what evidence, what data did you provide them, other than take your word for it?
Your Honor, among other things, we provided them evidence during the course of the difficulties of being able to protect the signal because of filtering. We provided example of I believe it was in May of 2019, and again in comments after we'd done a formal test, the difficulty of being able to protect the signal because of the electronic interference that was coming, the power interference. I mean, that's the biggest problem is the power level. You're putting a satellite signal that's coming down to Earth at a level of 0.1 to the 19th decimal point. The number's so small that I'm not sure that I've even properly stated it.
That goes to the interference problem, right?
That goes, Your Honor, to two things. It goes to the interference problem, but it also goes to the difficulty of operating in an environment where your signal is so saturated by the signals that are being emitted by the 5G transmitters. So it's not so much a frequency issue as it is a power saturation level issue.
If I'm remembering right, you told the FCC that you could sustain a loss of 200 megahertz And now you say you can't sustain a loss of 300 megahertz. I guess where can I go in the record to find that you produced evidence more than just your say-so that there's something about that extra 100 megahertz that allows you to service your current and future customers in a way that you wouldn't be able to if you lost that extra 100?
Well, Your Honor, if I could take us all the way back. We initially said that the ideal solution for the C-band was no spectrum.
I get that, but I think at some point you eventually said that it could sustain a loss of 200.
We said at some point that we could sustain a loss of 200 because the C-band Alliance, the then existing group of satellite consortia, had put 200 megahertz onto the table, and we felt that in order to try to make this proposal move forward, but we did provide evidence even at the 200 level. Those studies that I referred to on the interference problem were for the filtering, and I believe that we also I will go back to the record, Your Honor, but I will note that we raised the argument of the difficulty of being able to coordinate where you lose the frequency pair for the uplink satellite that is linked to the downlink satellite. So we raised that point to the commission, and I could go back and supplement the record for you.
And I'll stop asking questions now. Maybe in your rebuttal, if you could give me the JA pages that talk about those two experiments that you submitted, or what not.
Okay, thank you, Your Honor.
Thank you.
Your Honor, if I had an argument that I wanted to raise in addition to this regarding the Orbit Act, if I have time.
Briefly, please.
I'll just ask you, why doesn't North Point take that off the table?
Because, Your Honor, as we noted in North Point 1 specifically, the commission, this court said that the facts would be different if it was a service where there was currently international and global services being provided, which is specifically the case for which there's substantial evidence in the record.
The interpretive question is, what does the phrase used for mean? Does it refer to the old use or the new use? And we said the commission could permissively construe that to refer to the new use, and the new use here is not satellite.
Well, you said in North Point 1, Your Honor, you said that
Point 2.
Well, North Point 2, which was decided 2 weeks later and involved the service, which was strictly a domestic service, the 12 gigahertz MVDDS service, which involved a band where there was nobody currently using the band for international service. In our case, this band is specifically being used to transmit programming to and from the United States, which appears to be a pretty evident international service. The Congress's position was not just that you shouldn't auction this, it was notwithstanding any other provision of law, it should not be. It's interesting that in North Point 1, the court noted that the commission had even noted that it construed the relevant language of Section 765F, the Orbit Act, to focus on whether the particular spectrum being assigned is used for international or global satellite communication services. They didn't even do that here, Your Honor. They just simply said, we have the authority to do so. Where spectrum is being consistent with your holding in North Point 1, where spectrum is actually being used for global and international service, as it is here, the auction is prohibited by the Orbit Act. We are out of time, and we rest on our briefs on the other issues that we raised, but we request that the court vacate the order.
All right, I'll give you a little bit of time on rebuttal. We'll hear from Mr. Wright.
Thank you, Your Honor, and may it please the court. I'm representing the SSOs, which are the 3 smallest of the 8 satellite operators licensed to use the C-band.
Your voice is barely coming through. If you could turn up your mic or get closer to your mic, please, sir.
I will do my best, Your Honor. I'm in my office and our IT guy is going to turn up the mic, I hope.
All right, say something now, because I think it was getting better.
Well, thank you, Your Honor. Let me dive in on modification. The question before the court is really a legal issue, subject to Chevron standard. It's what the word modify means and whether it can bear the interpretation that the commission has given it here, which is that it just means you can serve your existing customers. And we think that's plainly wrong, where we've lost 60% of our spectrum. The question is whether licenses were modified. It's never been a question before. This is a completely unprecedented interpretation of modify, to say you look at whether you can serve your existing customers. And it's completely unfair to new entrants, such as my clients, who had to invest tens of millions of dollars before they could make a single dollar. And we've detailed ABS's experience in some detail in our brief to show that it built a satellite that can provide service until 2042, and yet the commission is taking away 60% of what it can sell, and that seems to us to clearly be an unreasonable interpretation of the word modify. So we're challenging the existing customer standard here, and think we don't. Therefore, the court doesn't need to get to the FCC's argument about whether or not our clients could have sold more than 200 megahertz of spectrum in the next couple of decades. As we've explained in our brief, we think they're clearly wrong on that. But first and foremost, it's a legal issue. With respect to the facts, with respect to our clients, the commission has contradicted itself. It says that the CONUS model, where you sell satellite service within the continental United States, has essentially lost out to fiber. And then it blames us for doing an intercontinental approach, under which we would bring video and other services into and out of the United States to different countries, and then rely on fiber in the United States. So again, I don't think the court needs to reach that issue, but modification means to change in incremental or minor fashion, this court said in Selco, and the focus should be on licenses, and taking away 60% of the license is more than a modification.
Didn't the commission find that the remaining 200 megahertz would be enough, not only for existing customers, but for any reasonably expected future demand?
So it said that. I would say, as we've shown, that it clearly adopted an existing customer standard and then fell back to saying, well, and USSOs are unlikely.
Suppose that finding of fact about current and reasonably expected future demand is not clearly erroneous. Why wouldn't that be more than enough to cinch up their case on the legal question? I mean, you're losing 60%, but turns out that doesn't matter much, because any future demand can be met.
Right. Well, Your Honor, again, I'd stress that if you look at their reasoning for that, it contradicts itself. They say there's no future demand. We would have to sell satellite service within the continental United States. That's not what we're planning to do, and it basically just ignored that. Let me turn to our fair notice argument, however, where the the applicable standard of review is much less favorable to the commission. Now, again, let me say that this existing customer standard was unprecedented here. The commission has always made licensees in our position whole. They often move, as Mr. Gavin was saying, somebody with a 6 megahertz to 6 other megahertz and pays the relocation, or has the new licensing pay the relocation, and that's what we expected here. We have no reason to think that we wouldn't keep the same amount of spectrum one way or another, or be compensated for our losses. And let me just say that the most recent case, the 24 gigahertz case from 2018, is very much like this case. The commission cleared broadcasters to make room for 5G, and it offered to pay them if they didn't want to get moved, but simply wanted, to trade 6 gigahertz or 6 megahertz here for 6 megahertz there. But under Trinity Broadcasting, in one of the most relevant fair notice cases, the commission does not do any deference when applying an unprecedented rule like the existing customer standard. Rather, the issue is whether its interpretation of the statute was, quote, ascertainably certain, unquote. That's at 242 F3rd at 628. And in this case, not only was it ascertainably certain that the commission was going to apply an existing customer standard, our clients had no reason at all to believe that there would be that such a standard would be used here.
Mr. Wright, can you tell me about your notice argument? If we assume that the FCC's order did not apply a blanket existing customers standard, but instead applied a standard that considers past customers, present customers, and reasonable expectation of future customers, found in the context of small satellite operators that there was no reasonable expectation of future customers. And so there, as a shorthand for that fairly all-encompassing test, referred to it as the existing customers test. If I think that's how the order is best read, did you have notice of that?
No, Your Honor.
Okay, and why not?
Well, the commission's best case is motion. In every other case, the commission hasn't looked into anything like this or thought about whether or not a licensee could get by with less spectrum. It's fully compensated them, and it's said this on many occasions because it recognizes the importance of investment-backed expectations. But motion, again, their best case is helpful for us. It's the only one where a licensee lost spectrum without compensation for losing that spectrum. But that case is so different than us. The commission decided to move a licensee from 28 megahertz to a 20 megahertz block. And the licensee was very happy about that because international coordination rules had rendered its 28 megahertz block nearly useless. And so it, as the commission's order shows, it welcomed the change. And it was another company that complained to the commission that it shouldn't do that to motion. So in light of that background, the most notice we had concerning what the commission might do was might say, okay, we're taking 300 of your 500 megahertz, and we're going to give you 420 better megahertz of license of spectrum somewhere else. If they did that, we wouldn't have complained. If they did what they've done so many times before and say, well, we're gonna move you somewhere else, but we can't find it, so we'll give you vouchers to participate in the upcoming auction, or we'll compensate you in some other way. That's what we had fair notice of. And let me just say that
why do you need fair notice that they might defend their order with the notion of existing customers as relevant to modification? I mean, that's just part of the justification they're using to explain why they're shifting spectrum. I mean, it was crystal clear that the notice told you they were planning on shifting spectrum. Why isn't that good enough? And you could make whatever arguments you want about why they shouldn't.
They've just never done that before without making parties whole. And as we quoted in our brief, they've constantly said that in order to induce people to build out licenses.
Just on the notice point, you said they've never done that without making people whole. I understand that's one of your substantive arguments, but just not seeing on notice. The whole point of this from the outset was to shift satellite spectrum into 5G spectrum, and everyone knew that's what was at issue. Everyone commented in the administrative proceedings about why that was a good or bad idea.
Right, and our clients weren't obstructionists. We ultimately, we said, okay, but, and let me just point to one of the places with JA 339, the government suggests that we just said, go ahead and take our spectrum. Every time we said it's okay to repurpose the C-band, Your Honors, or FCC, we added something like, but of course we expected that we'll be compensated for relinquishing our spectrum use rights. And as I say, that's just always happened. Most of the time the commission has replaced it. It's getting harder to replace spectrum. So as I said, in the most recent example, the 24 gigahertz case, they gave licensees an option to get a voucher to participate in the upcoming auction or to take cash. We would have welcomed a resolution on that sort, but we just had no notice that we would lose spectrum without being made whole. And it just wasn't ascertainably certain. The commission has now repurposed spectrum many times without ever doing this. And again, I say that the commission's best case is motion, which is in fact nothing like this. Let me turn, if I may, to the commission also, while not compensating the SSOs in any way, the commission compensated the other 5 operators with $15 billion, and we presented the FCC with this clearly superior alternative that they just brushed off because I don't think they had a good answer, under which every operator could get fairly compensated for the loss of spectrum. Every operator could get their relocation costs covered, including relocation costs to do things quickly. And the larger operators with existing services could get a proportionate profit from doing all this. And that could have been done for $6.4 billion rather than $15 billion. And so, of course, our main concern is that the commission has given a war chest to our competitors, some of whom are failing and now have $9.7 billion and 10 or 12 new satellites that they can probably use to move into the intercontinental market. And this was just unreasonable. The commission's explanation for this was that it would be a gamble not to pay $9.7 billion in simply pure payments to do something the larger satellite operators said they could do, relocate by 2023. The only answer we got to our proposal was that it would be a gamble. And the commission has explained in its brief that the gamble was that Intelsat and SES might bring, quote, a lawsuit to challenge the commission's legal authority to reduce its spectrum. And the FCC adds, quote, the commission is confident it would have prevailed in any such suit. So there's a reasonable alternative that would have saved the government $8.6 billion and kept that money from our competitors. And the commission's answer is that they were afraid that there'd be a lawsuit that had no merit. And so I think that's just not a reasonable explanation. The commission also suggests that there would have been an auction delay if it had adopted our more reasonable alternative.
Mr. Wright, you're over time, so I'm just going to ask you to bring it to a conclusion unless my colleagues have questions for this part of the argument.
Certainly. Let me just say their concern about auction delays is unfounded. If SES and Intelsat had come to this court and said, you need to stay the auction because $8.6 billion is not enough, and there's no public interest favored by keeping this money in the treasury, the court would have never granted stay. Thank you.
All right, thank you. We'll give you some time on rebuttal. So I believe next up is counsel for the commission.
Good morning. May it please the court. Ashley Boisel for the Federal Communications Commission. What the commission did here was exercise its broad spectrum management authority to repurpose underutilized spectrum in order to facilitate the immense and undisputed public benefits of rapid 5G deployment. The commission undertook this critically important effort based in part on Congress's direction to allocate mid-band spectrum for 5G, and also based on representations by the satellite incumbents, including the small satellite petitioners, that they could provide their services in the reduced 200 megahertz allocation with compression and other readily available technology. The commission's action here, both in terms of the 316 modifications of specific licenses and the setting of the accelerated relocation incentive payment, was in service of the public interest and warrants deference. And I think that the panel's questions suggest that you understand that what the commission did here was apply a comparable service standard that looked both to the level of existing customers as well as evidence that went to the credible likely future business. And the commission expressly found that the upper 200 megahertz allocation would accommodate both the existing level of business and the incumbent's ability to expand their business in the future. That comparable service standard is consistent with the text of the Communications Act, and it's consistent with this court's precedent in cases like Community Television and Selco Partnership and California Metro. With respect to the textual argument,
Ms. Boisel, on that point that you just made about how the order considered a potential future customers' reasonable expectations of them, is there anything in the Auto Innovators brief in terms of what that brief suggests this court should do? Is there anything in it you disagree with?
Yes, we think that what the amicus are asking for is a determination by this court about the legality of an existing customer standard. And that is not what the commission applied here. The commission applied a comparable service standard. And since the question of the legality of an existing customer standard alone is not squarely presented here, we don't think that the court needs to reach that question. Instead, as I said, the commission applied this comparable service standard, which ensured that the satellite incumbents and the Earth station incumbents could provide substantially the same service after the modification.
I guess you're not defending the existing customer standard. You're saying you don't want us to rule it out for the future. But I guess I would be curious why. I know you don't think we should reach it, but why why would it be wrong to rule it? Why would it be wrong to rule it out for the future? It does seem like an arbitrary and capricious standard.
Well, I think there may be opportunities in the future to address that question squarely, but as I said, that's not what the commission did here. And to the extent the court may have concerns about the commission's consideration of things like reliance or investment, I think that the court can take solace, A, in the fact that the commission looked at those factors here, and B, those are the kinds of considerations that would typically play a part in a public interest analysis. And 316 is tethered to public interest determinations. So I think
in this case, Ms. Boiselle, if you had, and I'm sorry if you're hearing some construction work nearby. In this case, if you had said to small satellite operators, we are not going to look at any potential future customers. We are only going to look at your existing customers. Would that have been arbitrary and capricious in this case?
Well, I think that we can see that it's appropriate to look at evidence in the record of reasonably credible future business prospects, particularly for newer entrants. Although I quarrel with the characterization of these small satellite operators as new entrants. They've had market access for quite some time. As to the existing customer and existing service standard that appears in this order, I think, Judge Walker, some of your questions seemed to understand that the existing customer and existing service information was particularly salient here because there was evidence in the record that the market was declining. And as a result of the fact that there were these long-standing satellite incumbents in a declining market, the existing customers were a particularly relevant and salient data point in ensuring that the incumbents could continue to provide substantially the same service after the modification as they could before. I want to move, with the court's indulgence, to the accelerated relocation payment amount. As a preliminary matter, I think that it might help to contextualize that amount against the commission's specified objectives. And it set forth those objectives in the discussion of this amount in paragraphs 211 to 226 of the order. And it made clear that what it was trying to do was maximize the likelihood that these satellite incumbents would voluntarily opt in to clear both themselves and thousands of Earth stations on an accelerated basis. And in addition to that objective, it wanted to ensure no service disruption, that the amount was an amount that the incoming overlay licensees were willing to pay, and that it increased the value of the transition overall to the public. This $9.7 billion figure achieved all of those objectives. And the commission reasonably explained why it was engaged in a line drawing exercise with no precise answer based on imperfect information, because the large satellite incumbents had no incentive to divulge what they would accept. So the commission started by evaluating the upper bound, and as it explained, that upper bound was a conservative estimate of the market value of acceleration to the overlay licensees. And then it selected a number close to that upper bound because, again, it was looking to maximize the likelihood of voluntary accelerated clearing on the understanding that that would result in social and economic benefits on an order of magnitude greater than the market valuation of acceleration to the overlay licensees. And some estimates suggested that that would mean $15 billion a year for each year of acceleration, so $30 billion total, hundreds of thousands of jobs, American leadership in 5G with attendant national security interests. So I want to push back against this narrative that in selecting that number, the commission abdicated its responsibility to the public interest. That's simply untrue. There are different ways to enrich the public, and the commission ensured that the Treasury revenue was accrued via the public auction, and that the public also reaped enormous social and economic benefits aside from the Treasury revenue. With respect to some of the representations by petitioners' counsel, as I said, I think the panel understands that the commission relied on substantial evidence in the record in determining that both PSSI and the small satellite operators could continue to provide service in the reduced 200 megahertz allocation. PSSI failed to offer sufficient evidence to suggest that its ability to run its business would be eliminated. and the small satellite operators failed to overcome countervailing evidence in the record that the market was in decline, or to demonstrate that they would be able to lure their customers away from their larger satellite competitors. With respect to notice, I think Judge Katsas, some of your questions indicated that you understand that it may not be the case here that particularized notice was required. Of course, it's our position that it wasn't, that this is not a sanction, and that there was adequate notice that the commission could exercise its broad spectrum management authority in this manner. And with respect to the small satellite operators and the evidence that they submitted, I also want to point out, as I did in my introductory remarks, that they actually favored the reduction of the 200 megahertz allocation, and that Judge Walker, I think it was you who remarked that PSSI had also suggested that it would be okay with a reduction of spectrum here. If the panel has no further questions, I'm happy to address other issues, but otherwise.
Judge Katsas, Judge Walker.
I do have one. I have a question on the small satellite operators standing. I don't think they have standing to challenge the payments from one company to another company. But what about their standing to challenge pretty much everything else? Would you agree that they have standing to raise all the other claims that they raise?
Well, we certainly didn't take the position in our brief that they lack standing, but this court can, of course, reach that conclusion in its own judgment. And I certainly don't want to be in the position of persuading you that they do. But again, that's not a position that we took in our brief.
Okay, that's fine. I'm good.
If there are no further questions, then we ask that the commission's order be affirmed in its entirety.
All right, thank you, counsel, and we will hear then, I guess, from the wireless intervener.
Yes, thank you. Peter Karangia for the wireless interveners, and we appreciate the court granting us time. I'd like to begin, Judge Walker, with your question about the amicus, and this is an important issue to us because our clients have an extremely strong interest in having this order affirmed. In our view, it's critical to free up much needed 5G spectrum that our customers are demanding, and that will enable a raft of innovative services that will promote telemedicine, telework, which we're all doing now, Internet of Things, and a number of new other innovations yet to be imagined. So we have a strong interest in seeing this order affirmed, but we also have a strong long-term interest because we are licensees. And we have no appetite for granting the FCC a blank check on Section 316 modification authority, as the amicus alleges and as the SSOs allege. And we simply don't think that this order did that. First of all, I think the critical point on that is the arguments from the other side rest on a misreading of the order. They assert without basis that the commission applied a singular existing customer standard, which is simply not true. And I would point the court to paragraphs 32 of the order, paragraph 139 of the order, paragraph 196 of the order, where it is crystal clear that the commission not only considered existing customers, of which there were practically none, but also looked at reasonable business opportunities. And we think that's important because it reflects a recognition, which is appropriate, of investment-backed expectations where there are such expectations. And so, for example, our clients have put enormous investments into their spectrum holdings, hundreds of millions of dollars, in fact. They're subject to build-out obligations. So yes, if the commission tried to sort of take away substantially all of their spectrum, we think that would be an issue. But I think the critical point here is these Section 316 questions are not analyzed in a vacuum. They are undergirded by a fact-intensive analysis, which I think has come out in the questions during the earlier colloquies. And moreover, that fact-specific approach is supported by this court's precedent. We cited in our intervener brief a case called P&R Tema, which said, look, when we're looking at this stuff, we go beyond the form of the license. We're not just looking at the words in a license. We have to look at the real world impacts, or as Judge Katsas, I think the phrase you aptly used in the earlier case was, what are the facts on the ground? And I think when one looks at the facts on the ground, that really is fatal to both PSSI and the SSOs for two reasons. First, they each conspicuously fell short in meeting their burden of proof before the commission. They tried to throw in a bunch of additional post-order evidence in connection with their stay motion, which this court denied, in the form of declarations, which tried to clean up things, but frankly, we don't think they even would have moved the needle if they had been considered. But in any event, as this court knows, post-record evidence like that is inadmissible effectively. Secondly, as this court has recognized, the substantial evidence standard is fatal to these arguments. The factual underpinnings of the Commission's 316 analysis are well supported in the record, and under that very deferential standard, the Commission must prevail. The other point I would make on the amicus brief arguments is, and we made this point as well in our intervener brief, you don't look at these issues in a factual vacuum as if to say that the Commission can just ignore the APA. Of course, everything the Commission does is constrained by the APA. That means the Commission has to look to reliance interests in virtually any context, whether you look at that through the lens of what is a modification or not a modification, or whether you look at that through the lens of is it in the public interest. And we've cited cases, this is black letter law, the Commission has to, like any agency, look at reliance interests. It has to explain its decisions cogently. And we believe it did all those things here. So we simply have no concerns about what the order set forth as a relevant standard and what that means for future cases. We think that the order should be construed as setting forth a holistic analysis that is heavily immersed in the facts. We think that's what the Commission did here. Now, on the acceleration payments point, my only addition there is to just point out perhaps an obvious fact, which is we're the ones paying those, we the wireless industry, that's on our dime. Yes, $99.7 billion is a substantial amount of money, of course, but the Commission was making a difficult and critical decision here. How do we draw the line in figuring out effectively what is the lowest amount we can set that would nevertheless sufficiently incentivize clearing on a quite expedited basis? They basically cut 2 years off the clearing timeline from 2025, which is the outside deadline, right? That's what all the incumbents must meet, the 2025 deadline. And they said, we're going to effectively move this forward by 2 years to the end of 2023 by providing you a carrot. And they actually refer to sort of using a carrot and stick approach, which is entirely proper.
Also, unless my colleagues have questions, I'm going to ask you to bring your argument to a conclusion. You're over time.
Absolutely, Your Honor. So we have interests on both sides of the equation. We stand by what the Commission did, and we ask the court to refer.
All right, Judge Walker, Judge Katsas, any questions for counsel?
No.
All right, thank you. Thank you, and we'll hear for counsel for intervener SES Americom.
Thank you, and good afternoon, Judge Wilkins. May it please the court. My name is Paul Warner, and I represent SES Americom. SES is one of the largest incumbent satellite operators with business on the C-band that is already actively working to transition its businesses, services, and customers into the upper 200 megahertz of the band to free up significant spectrum for deployment of revolutionary 5G services. With my limited time, I'd like to focus on the payment issues, and I'd like to pick up with Judge Walker's observation that the SSOs do not have standing to challenge the payments being made by third-party wireless overlay licensees to third-party incumbents. They plainly don't, and I would point the court to this court's decision in the mobile relay case. In order to have competitor standing, as they're alleging here, they need to be current and direct competitors. They're not. And that brings me to a fundamental distinction between the SSOs on the one hand and the incumbent satellite operators on the other. The FCC made a technical assessment based on its core competency in this area that the SSOs are nothing more than paper networks. They hold authorizations, but the FCC concluded, based on the evidence, that they did not launch their satellites to provide services in the C-band in the United States. They have no C-band business now. They have no Earth stations in the C-band in the United States. And because of the technical limitations of their satellites and the past business they have provided using the C-band, they are unlikely, the FCC predicted, to provide services in the future. They're free to do so in the same amount of spectrum going forward that is left for the incumbents who have real business in the C-band. The incumbents have billions of dollars of business in the C-band. SES alone has 16 satellites to provide C-band service in the United States. It has more than 100 customers. It has more than 100 services, and it is being impacted seriously by the transition along with the other incumbents who actually have services being provided to U.S. Earth stations, which number in the tens of thousands. In fact, there are 16,000 plus Earth stations that are going to be impacted by the transition. So as a result of their licenses being modified, the FCC properly determined that the incumbents will incur real and actual and substantial costs. This is an unprecedented undertaking that the Commission has set the incumbents out to accomplish on an expedited time frame. And I just want the court to understand the expedited nature and the significant undertaking that is required to transition out of the lower 300 megahertz. SES
Mr. Warner, do you agree that your petition at this point should be dismissed?
The petition, yes.
Okay.
So as I was saying, and I recognize my time is up, but the incumbent satellite operators, in order to transition the services, are already incurring substantial costs in the order of billions of dollars. Those costs are set out in transition plans filed with the Commission, and they will be vetted and reimbursed through an independent clearinghouse. Now, quickly, just on the incentive payments, those payments are to incentivize SES and the other incumbents to take on voluntarily the massive costs, the logistical challenges, and the business and execution risks to carry out the transition at a breakneck speed, all while seamlessly delivering video and radio content to more than 100 million US households. The FCC correctly recognized it would take a substantial incentive for the incumbents to take on that profound task, given the risks and costs involved. And the FCC did not accept the amount that the incumbents actually sought to perform that accelerated relocation. The FCC provided an amount far less than that. That amount that the FCC actually approved is also far less than the value that the incumbent satellite operators are going to deliver to the American public by freeing the spectrum on an accelerated timeline. It's also less than the value to the wireless overlay licensees of obtaining the spectrum early. If there are no further questions, I'm happy to answer any questions, but if there are no questions, I see my time is up, and we would ask that the Commission's order be affirmed.
Okay, Judge Katsas, Judge Walker, any questions?
No.
All right, thank you, counsel. So now rebuttal for Mr. Gavin. I believe you were out of time, but we'll give you 2 minutes.
Thank you, Your Honor. I just wanted to address first Judge Walker's question. We reported to the Commission on numerous occasions the issues of the power saturation and the difficulties that we're going to be encountered with being able to deal with frequency coordination. I would refer you, Judge Walker, to our ex parte that were filed May 6th of 2019, that's JA 270. November 15, 2019, that's JA 380. January 8, 2020, which is JA 401, and February 20, 2020, which was JA 464. The Miami Hard Rock Stadium was an example that was provided afterwards, but the issues we addressed the issues prior to that. I also wanted to, with my time remaining, just to touch on something that counsel for the commission said. I repeat what we said from the beginning. We were concerned even about 100 megahertz being reallocated, but we ultimately accepted the idea that 200 megahertz could be allocated. And if my calculations are correct, something like the Miami, and I'm guessing others of those frequency coordination studies would still work if it were only 200 megahertz being transitioned. The last thing is the issue of programming demand, and we submitted in our briefs and cited in the record repeated assertions by, among others, the NAB at JA 444 about the importance of occasional use, and ESPN specifically reporting that there was an increased demand that they had for C-band services in these last several years. So that is at JA 278. I thank your honors, and I repeat, we seek that the order be vacated, and thank you for consideration of our argument.
Thank you, Mr. Gavin. Mr. Wright, you were out of time, but we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. On modification and notice, so it was noted that the FCC hardly defends its existing customer standard, even though the commission articulated that many times. It was suggested, as we of course think, that it's an arbitrary, capricious standard. The following test about sort of whether or not we would be able to build customer base in the future is sort of an extension of the existing customers test. So if the existing customers test isn't the applicable test, I don't think we could have known that the commission would say, well, okay, how about future customers? And so we just didn't have notice of that. And no one has cited any case, again, where a licensee got moved without getting full replacement spectrum and or money, except motion. So my friends in the wireless industry, basically say this rule would be unlawful if applied to them. And the commission in paragraph 143 of the order sort of gave away that this was a one-time only a rule that would be applied. And I think that simply shows it's unlawful. I would also note that Mr. Karanja articulated the standard we think should apply and Congress thinks should apply with respect to determining the payments beyond payments for actual relocation costs. That standard is to determine the amount of compensation the licensees would accept to move. The FCC thinks it has authority to order them to move. We actually agree, but it has to compensate them for doing so. One other point, SES will get all of its relocation costs covered, including any relocation costs to do it faster, to do it on an accelerated basis. I hope the court understands that and that the $9.7 billion is simply pure profit rather than compensation for expenses.
All right, thank you, Mr. Wright. We have all of your arguments and the case is submitted.
This honorable court is now adjourned until Monday, November 2nd at 9:30 a.m.